if this so-called ongoing concern value is factored into the amount of the reasonable real value of the terminal facility, AADC is willing and prepared to pay this amount. And because government has already paid the initial amount of $3 billion, AADC is willing to reimburse government with respect to the payment of this 3 billion pesos, Your Honor. But the going concern value that that has been mentioned here, Your Honor, must not be interpreted to mean that the value of the terminal facility will go beyond its actual or reasonable value, because in that situation, if that were paid to Piatco, then the reverse situation will happen where it is Piatco that is being enriched at the expense of another. The draft concession agreement, which was the contract bidded out, provides that the terminal facility will be completed by AADC for an amount of at least $350 million, Your Honor. Whatever that amount will be to complete the facility, AADC is prepared to do as well.
Okay. Thank you, Counsel.
Justice Callejo.
Counsel, the MOA was executed by the DOTC and Dragon, may I use the word Dragon instead of AEDC, on February 26, 1996. You affirm that?
That's correct, Your Honor.
Subsequently, Dragon filed a complaint or petition in the RTC for nullity, declaration of nullity of proceedings, mandamus, and injunction. And this is docketed as civil case number 66213 in the RTC in Pasig City. Do you confirm that?
Yes, Your Honor.
In fact, in that petition of Dragon, Dragon also prayed that a writ of mandamus be issued directing the respondents, including DOTC, to award to petitioner the NAIA IPT-3 project in the absence of any other qualified proponent submitting a lower bid. That was your main relief in mandamus. Do you affirm that?
That was the main relief of AADC, Your Honor. I affirm that.
But that complaint, that petition did not proceed because the parties filed a joint motion to dismiss the petition. Do you affirm that?
Yes, Your Honor.
Was that granted by the court? Did the court grant the joint motion to dismiss and dismiss the petition?
The joint motion to dismiss, Your Honor, specifically was only for purposes of dismissing the case without any of the parties waiving any rights. It did not involve any waiver of rights because precisely the joint motion to dismiss preserved the positions, respective positions taken by government and AADC insofar as the issues raised before the Pasig court is concerned. The court dismissed the case on the basis of this joint motion to dismiss, but included a standard phrase that is normally included, which said that it was a dismissal with prejudice. But the record will bear out, Your Honor, that in fact the dismissal of that case was never on the merits, precisely because of the terms of the joint motion to dismiss.
I am bothered by your statement that it is a general blah, blah, blah. When the court dismisses a complaint with prejudice, that is of great legal significance. It cannot be refiled anymore. Did you notice that?
Yes, Your Honor. I agree with that premise, Your Honor. But I would like to point it out that the issues that were raised in the Pasig case involved three main issues, actually three issues only. One was the nullity of the proceedings in PBAC. The second was AADC's claim to have its right to match protected. And the third was a declaration that there was no qualified challenger to the original proposal. These were the issues raised in the Pasig case. And these issues, this case was dismissed. And even assuming for the case, for the sake of argument that this case was dismissed with prejudice and on the merits, the fact of the matter, Your Honor, is that what happened in the Pasig court has been rendered moot by the decision of this honorable court in Agan versus Piatco, where AADC was not a party to that case. This honorable court, through the arguments no less raised and support made by government and the petitioner DOTC, that the contract at that point in time was a nullity because it did not comply with the BOT law, was decided by this honorable court. And therefore, the question of whether or not this was dismissed with prejudice or on the merit has been mooted, has been totally irrelevant. The issue that we are raising here now before this honorable court is entirely a different issue. It is an issue that takes on a different legal threshold. And this is the issue of whether, on the basis of the Agan decision that decided with finality the issues that were raised in the Pasig court, has the right to the award of the terminal facility on the basis of the fact that its right to that award vested even before the Agan case was promulgated, Your Honor.
I have compared the material aberments of your petition in the RTC in Pasig and your petition in this court now relative to the petition for mandamus. They're the same. You read your petition in the RTC in Pasig and your petition for mandamus now. The legal and factual basis are the same. Are the same. And yet, you are filing the petition in this court despite the order of the RTC specifically that the order is with prejudice. But you are refiling the petition in this court practically on the basis of the same factual and legal basis as alleged in the RTC in Pasig. Is that not barred by Rule 39, Section 49, Paragraph B of the Rules of Court?
No, Your Honor, because the allegation of factual basis in this petition is merely a reiteration and culling of the facts that was already in the Agan case. We just did that for purposes of explaining to this honorable court how the right of AADC came about. While the factual allegations are the same, the prayer and the issues are different, Your Honor. And this is the point that I would like to underscore here, Your Honor. The issue that we are raising here now is limited to whether or not AADC has the vested statutory right, which came about when Payer Cargo was disqualified as a bidder, but which can only be raised after this honorable court came up with its decision in Agan that has become final, Your Honor.
One other point. When the court nullified in Agan the Piatco contracts and agreements, should not there be another bidding?
No, Your Honor, because the BOT law with respect to unsolicited proposal is very specific on this matter. This is the essential feature of an unsolicited proposal that makes it different from the usual public bidding of BOT contracts or infrastructure contracts. Under Rule 10 of the implementing rules and regulation of the BOT law, once the unsolicited or the original proposal goes through that stage of a Swiss challenge, at that point, there is no other option on the part of government but to award the BOT project to whoever is qualified on the basis of the outcome of that Swiss challenge. There are only 3 instances at which the respondent DOTC may be allowed to rebid or bid out the project. And the respondent DOTC have gone way past that stage, Your Honor. And if I may, just to enlighten this court, the 3 instances at which government will be able to bid out the project will be: 1, when in the negotiation process with the original proponent, they have not resolved differences, and therefore the 90-day has expired, and at that point, respondent DOTC may reject the proposal and bid the project out. The other, Your Honor, is when the original proposal as an unsolicited proposal is submitted to DOTC for purposes of having it processed under the unsolicited mode. In that particular instance, government or DOTC has the option to evaluate the original proposal or the unsolicited proposal within a period of 60 days, and if it is not satisfied, may again reject the proposal and then bid out the project to third parties. And then the third, Your Honor, is when there are multiple submissions of unsolicited proposal, where at that particular instance, the DOTC may outright reject everyone and bid out the project. So these are the only 3 instances. And the point I want to emphasize here, Your Honor, is once government or once the DOTC has gone past that stage of in-depth negotiations, and in fact, the proposal is now being submitted only for a Swiss challenge, there is no more any occasion for government or the DOTC in this particular instance to bid out the project.
I'm very happy that you cited the opinion of the Chief Justice in Agan, because it is my honor that I concord with his opinion. May I read a portion of his opinion?
Yes, Your Honor.
If the PIATCO contracts are junk altogether, as I think they should be, should not AEDC automatically be considered as winning bidder and therefore allowed to operate the facility? That was the question of the Chief Justice. And his answer is, to which I concur. My answer is a stone cold no. AEDC never won the bidding, never signed any contract, and never built any facility. Why should it be allowed to automatically step in and benefit from the greed of another? Question mark. So my question to you was, is there a need for another bidding for Dragon to be entitled to any award?
No, Your Honor. As pointed out in the passing remark of the Honorable Chief Justice in a separate concurring opinion, he is correct in that AADC did not win any bidding. But AADC, Your Honor, is entitled to the award of the project because under the BOT law with respect to unsolicited proposals that have been accepted on a negotiated basis, it is entitled to the award of the project as a matter of right when one of the suspensive conditions, as pointed out in the law, comes about or is fulfilled. And in this particular instance, that suspensive condition is that no other proposal was received within the period of the Swiss challenge. So in that respect, Your Honor, AADC is entitled to the award of the project, not because it won the bidding, because this was not a bidding for AADC, but because it was entitled under that provision of law. The bidding process alluded to is in the Swiss challenge, where it's really a bidding process for the challenger to outbid the proposal of the original proponent. But even in that respect, Your Honor, the original proponent is given that special protection and preference, because if there is a lower price than that proposed by the original proponent is given the right to match. Secondly, Your Honor, the second point raised by the Honorable Chief Justice in his remarks is that AADC is not just going to automatically step in as if without paying anything. Otherwise, it is correct. AADC will be enriching itself at the greed of another. AADC, as I pointed out, as it steps into being the legitimate and unchallenged original proponent entitled to the award, will be paying Piatco compensation for the reasonable cost and real value of the terminal facility based on quantum merit, Your Honor.
Further questions from the members of the court? Justice Minita Chico Nazario.
You spoke of protection under the unsolicited proposal provision of the BOT law as amended.
That's correct.
Now, what is the scope of this protection, Attorney Yasay?
The scope and the thrust of this protection, Your Honor, was in fact to stop and discourage the unlawful practice that was previously happening, where a proponent of a project goes at tremendous cost and expense, investing time and money in the preparation of innovative proposals to help solve the infrastructure problems of the country, when in fact, in the end, the award of the contract is given to someone else because of anomalies and corruption of government officials. This is exactly what has happened in the case of NAIA Terminal 3. And the scope of protection that is given to the original proponent is that, first, if there is no original or rather other proponent with submitting a proposal within that 60-day period, it is entitled as a matter of right to the award of the project. And then the other protective feature is that when a proponent submits a lower price, again, the original proponent is given that right to match. So the point here is that the protective scheme or feature starts off when government accepts the project and implements it under an unsolicited mode, which means at that point, government cannot even entertain any other similar projects until the period of the Swiss challenge. That again is another feature of protection that is given or accorded the original proponent. By the time it reaches the Swiss challenge, Your Honor, the original proponent in that respect, as part of its protection, is virtually assured of the award of the project, subject only to the two suspensive conditions that I mentioned earlier.
So, isn't the 30 working day period to match the challenger's lower price proposal the only protection afforded the original proponent in the BOT law?
No, Your Honor.
From my reading of the provisions of the BOT law, it would seem that the only protection afforded to the original proponent is its right to match the lower price proposal of the second proponent.
Yes, Your Honor. I would like to agree to that proposition, Your Honor, except that if that is the only right given under the BOT law, particularly Section 4A of the BOT law, then an absurd situation will arise where when there is no other proponent that submits a proposal to contest or challenge the original proposal of the original proponent, then the efforts and time and investment that was given to the original proponent will go to waste and will be for naught. Because at that point in time, if I were to follow the argument, the project cannot be awarded to the original proponent, and at the same time, it cannot also be bidded out because the law prohibits the bidding out. So, reading the provisions of Section 4A, Your Honor, it is very, it's very imperative, it's very unmistakable from this representation that even as the law did not absolutely express this as a right, yet it is very clear that the law intended it to be a right, that when there is no other proponent that submits a price challenge within the mandatory 60-day period, then the project should be given to the original proponent. That's the only way that Section 4A would make sense, Your Honor.
So it is your view that such protection extends to the automatic awarding of the project to the original proponent when the contract entered into with another proponent was subsequently annulled?
How is that again, Your Honor?
It is your view now. You're trying to convey to the court that the protection which you which I mentioned and which you in which you concur extends to the automatic awarding of the project to the original proponent when the contract entered into with another proponent was subsequently annulled? Is it is your view now that just because the contract entered into with the original proponent was subsequently annulled, the award of the contract to the original proponent is automatic?
No, Your Honor, I am not saying that at all. Your Honors, what I'm saying here is that the right of AADC to the automatic award of the project vested long before the nullification of the Piatco contracts by this Honorable Court. At that point, it was entitled to. However, because government was a participant at that time in the unjust and unlawful award of the project to Piatco, there was no way that AADC could enforce its right. Therefore, unfortunately, this Honorable Court decided to nullify this contract on the basis precisely of the irregularities and anomalies that had been pointed out. But it does not mean that the right of AADC vested because of the nullification of the Piatco contracts. No, Your Honor. The nullification of the Piatco contracts only paved the way for the enforcement and recognition of the vested right of AADC to the award of the project that vested at the time that Pair Cargo failed to qualify as a challenger at the time it submitted its price proposal.
Why do you say that it has already acquired a vested right?
Precisely, Your Honor, because under the provisions of the BOT
Is there any
law,
provision
yeah,
in the,
and the
in the BOT law that,
Yes.
that under such circumstances, the original proponent will have to, has already a vested right
Yes, Your
on
Honor.
his proposal?
When the original proponent is not subjected to a price challenge within the mandatory 60-day period, the original proponent is